Good afternoon. While the present me is on a flight to Beijing, the past me would like to talk a little bit about the Supreme Court and the right to die. I'd like to talk about two recent cases, which are written behind me. The first is Washington versus Glucksberg in 1997, and the second, which we'll get to a little later, is Gonzalez versus Oregon in 2006. In the Washington versus Glucksberg case, Dr. Glucksberg and some of his colleagues and a few terminally ill patients, along with the support of an NGO, decided to sue the state of Washington in an attempt to overturn a 1979 state law which said promoting a suicide attempt is a felony. And it said that anyone who knowingly causes or aids another person to attempt suicide is committing such a felony. The plaintiffs in this case cited the 14th Amendment's state's restriction on due process. That says, "Nor shall any state deprive any person of life, liberty, or property without the due process of the law." Hence, we have a federal constitution statute, a restriction on the powers of the government, and an inherent right to privacy and a right to decide when to die, pitched against a state law. And the Supreme Court was asked whether the 14th Amendment implies a sort of right to die and a right to physician-assisted suicide, so explicit that it would trump the state law. The court voted unanimously that it did not. That is, that the state law takes precedence, and that the 14th Amendment does not contain an inherent right to die. The court stated, in their majority opinion, that this asserted right has no place in our nation's traditions, given the country's consistent, almost universal, and continuing rejection of the right, even for terminally ill patients, to die. They were very concerned about protecting the medical profession's integrity and ethics, and also their role as healers. They also worried about the psychological and financial pressure that could be put on vulnerable patients to end their lives. And that was Chief Justice Rehnquist, now deceased, who wrote that opinion. So the Supreme Court said that the Constitution does not guarantee a right to die, but that states could experiment with laws regarding the right to die, as there is no explicit federal law establishing or prohibiting physician-assisted suicide, and there is still none today. Consistent with that, voters in Washington State in 2008 passed Initiative 1000, which said that a physician can in fact assist in a suicide for a terminally ill patient, although they did say that that patient must ingest the drugs themselves, which obviously raises complications in certain types of diseases. So there you have it. The Supreme Court says that the Constitution does not guarantee a right to die, but that there is no explicit prohibition against physician-assisted suicide either, and thus it is left up to the states to decide. So that's the case from 1997. We'll get to the later case after a short break.